Let's go to this press conference.
With me today are my colleagues, Rob Kazami, Director of the Division of Enforcement at the Securities and Exchange Commission, U.S. Attorney Tim Johnson of the Southern District of Texas, Kevin Perkins, Assistant Director of the Criminal Investigation Division of the FBI, Eileen Mayer, Chief of the IRS Criminal Investigations, and Greg Campbell, Deputy Chief Inspector of the U.S. Postal Investigation Service. Today, in the Southern District of Texas, an indictment charging R. Allen Stanford, chairman of the Houston-based Stanford Financial Group, and 4 other individuals was unsealed. The indictment alleges that Stanford and his co-defendants engaged in a scheme to defraud investors who purchased approximately $7 billion in certificates of deposit, CDs, administered by Stanford International Bank Limited, an offshore bank controlled by Stanford and located in the island of Antigua. According to the indictment, Stanford and his co-defendants allegedly misused and misappropriated most of those investment assets, including diverting at least $1.6 billion into undisclosed personal loans to Stanford himself. All the while, Stanford and his co-conspirators allegedly misrepresented to investors the financial condition of Stanford International Bank, its investment strategy, and the extent of regulatory oversight by the Antiguan authorities. For example, the indictment alleges the following: that the defendants falsely claimed that Stanford International Bank's assets grew from approximately $1.2 billion in 2001 to approximately $8.5 billion in December of 2008. As alleged in the indictment, approximately $5 billion of the reported assets consisted of notes on loans to Stanford and grossly overstated interests in island properties. That Stanford International Bank's reported assets were heavily manipulated through the inclusion of personal loans of at least $1.6 billion made from investor funds to Stanford, as well as a round-trip real estate transaction that saw Stanford International Bank spend $63 million in Antiguan real estate last June, only to sell the undeveloped property through Stanford control entities back to itself, claiming its value this time at the end of last year to be in excess of $2 billion, from $63 million to $2 billion. That Stanford and his co-defendants, one, falsely represented to investors that Stanford International Bank's investment strategy was to minimize risk and achieve liquidity, and that client funds were placed in safe and secure investments, and promised returns on CDs that in the end were simply too good to be true in light of the bank's actual investments and assets. That Stanford and his co-defendants made false and misleading representations about the regulatory scrutiny of the bank by Antiguan authorities, when in fact Stanford and his co-defendants were making corrupt payments to the former head of Antigua's Financial Services Regulatory Commission to ensure that the regulator did not actually and accurately audit or verify the assets reported in the bank's financial statements. The indictment charges Stanford with conspiracy to commit wire fraud, mail fraud, and securities fraud, 7 counts of wire fraud, 10 counts of mail fraud, conspiracy to obstruct an investigation by the SEC, obstruction of an investigation by the SEC, and conspiracy to commit money laundering. Mr. Stanford was taken into custody by federal agents in Virginia last night. Also charged today and arrested this morning in Houston was Gilberto Lopez, the Stanford Financial Group's chief accounting officer, and Mark Kurt, the global controller for Stanford Financial Group Management. All are expected to make court appearances this afternoon. Also charged today is Leroy King, the former administrator and chief executive officer of Antigua's Financial Services Regulatory Commission, an agency of the Antiguan government that is responsible for monitoring and regulating banking activity on the island. As alleged in the indictment, Stanford paid King hundreds of thousands of dollars for his assistance in ensuring that Stanford International Bank was not the subject of close scrutiny by Antiguan as well as U.S. regulators. Laura Pendergast-Holt, the chief investment officer of Stanford Financial Group, who is also charged today, was indicted in Houston last month for obstruction in an SEC investigation based on false representations that she is alleged to have made at an SEC proceeding in Fort Worth earlier this year. We expect Ms. Pendergast-Holt to appear in federal court in Houston next week. And James Davis, the chief financial officer of SFG, has been charged in a criminal information for his alleged role in the conspiracy. In addition, in the Southern District of Florida, an indictment was unsealed today charging Bruce Perot, an SFG security specialist, with destruction of company records after a federal judge had ordered that all SFG documents be retained. Perot was arrested in Broward County, Florida, this morning. The Department of Justice will vigorously root out and expose financial crimes that wreak havoc on innocent investors. Investors need access to accurate and truthful financial information in order to make decisions about how to invest their hard-earned savings. Their savings, and indeed the integrity of our capital markets, are jeopardized when investors are deceived. These difficult economic times make the mission of the department all the more important. In addition to identifying, investigating, and prosecuting massive financial fraud, the department is committed to assisting in the recovery of investor assets and funds. When the SEC announced in its first civil actions against Stanford and its many corporate entities in February, the Federal District Court in Dallas appointed a receiver that thus far has identified less than $2 billion in recoverable assets. Our continued close cooperation with the SEC and the receiver has resulted in the freezing of more than $300 million in investor funds in bank accounts in Switzerland, the United Kingdom, and Canada. In addition, the receiver has determined that an estimated $1 billion in funds controlled by Stanford still cannot be located. We are working diligently to locate further recoverable assets. Unraveling massive international financial fraud schemes can be a daunting task. Through the strength of our cooperative multi-agency relationships, the Department of Justice and the FBI, working together with the SEC, the IRS, and the U.S. Postal Inspection Service, were able to expose this long-standing alleged conspiracy. There are many thank yous to go around here. First and foremost, I want to thank the Securities and Exchange Commission for its tireless work on this complicated case. Their resilient dedication in the face of alleged continuous obstructive behavior is to be commended. I want to thank the investigative efforts of the FBI and the postal inspectors, and I want to thank U.S. Attorney Tim Johnson of the Southern District of Texas for the magnificent work of his office. I want to thank the fraud section of the criminal division, as well as the asset forfeiture and money laundering section of the criminal division as well. And in particular, I want to thank attorneys Jack Patrick, Matt Kleka, and Paul Pelletier of the fraud section, as well as Assistant U.S. Attorney Greg Koster of the Southern District of Texas, who are diligently working in Texas on this case as we speak. Financial fraud of any type is intolerable, and the American people should be assured by today's actions that the Justice Department and its partners will remain vigilant in rooting out all such fraud. I now want to hand the podium over to my friend and colleague, a terrific lawyer and public servant, Robert Kazami from the SEC.
Thank you, Lanny. Good afternoon. My name is Robert Kazami, and I am proud to represent the men and women of the SEC's Division of Enforcement as its director. On February 17th, the SEC charged Alan Stanford and two of his associates with a massive fraud. At that time, we alleged that Stanford committed that fraud through a close-knit network of associates. With today's charges, we see the inner workings of how that network worked, and it paints a very disturbing picture. We have alleged in today's charges that three additional persons enabled Stanford to both operate his scheme and avoid detection. Two who helped him cook his books, and a third who helped him, who looked the other way. In our amended complaint, we charge accountants Mark Kurt and Gilbert Lopez with committing and aiding and abetting securities fraud. Kurt and Lopez fabricated the financial statements that enabled Stanford to lie to investors about the circumstances surrounding their investment. Placed in a position of trust, these men manufactured the performance numbers to tell investors a fictional story about how their investments were safe, solid, and secure. And in a shocking twist to this story, Stanford's scheme also corrupted a foreign regulator. Today, we charge Leroy King, the administrator and CEO of the Antiguan Financial Services Regulatory Commission, or FSRC, with aiding and abetting securities fraud by accepting thousands of dollars in bribes on a regular basis to ignore the Stanford Ponzi scheme. We allege that King saw to it that audits and examinations of Stanford's operations were a sham. He made sure that the FSRC did not examine the underlying investment portfolio. And in a stunning breach of confidence for any regulator, King provided Stanford himself with access to the FSRC's confidential regulatory file on Stanford, which included the SEC information requests about Stanford's operation. And indeed, King went so far as to allow Stanford to essentially dictate the responses that the FSRC would give to the SEC in response to their information requests. Thus, when King assured the SEC that Stanford was safe and was solid, these were not the conclusions of an independent regulator following a thorough audit or inspection. These were just more of Stanford's lies dressed up in the letterhead of a supposedly impartial regulator who had in fact been bought and paid for through bribes and corruption. Let me read from the complaint what King told the SEC in his letter of 2006, and this is in paragraph 22 of our complaint. We wish to assure the SEC that the FSRC's most recent on-site examination, conducted just 5 months ago, confirmed Stanford International Bank's compliance with all areas of depositor safety and solvency, as well as all other rules and regulations. By doing these deeds, Leroy King put personal greed ahead of his public trust. He abused his position of authority, and instead of being the investors' protector, he was their enemy. Perhaps what is most disturbing about this case is that Stanford's victims were not looking for one of those get-rich-quick schemes that we hear so much about and seem somewhat obvious to avoid. Stanford's investors were simply looking for safe investments and low-risk opportunities. And with Stanford, they thought they had found such an opportunity. But what they had actually found was a complicated array of phony financial statements, fabricated performance, and sham audits, all to create the illusion of safety and liquidity. And it was an illusion created in part by these three men that we have charged today, all of whom rented out their expertise and their positions of authority. As we were investigating this case and trying to raise the curtain on this fraud, they were doing everything they could to keep that curtain down. I want to conclude by thanking Lanny Brewer and my former colleagues at the Department of Justice who have worked tirelessly to build an impressive criminal case from the rubble of this massive fraud. The DOJ prosecutors deserve special recognition not only for today's charges, but for their tireless efforts in locating and securing investor assets in many